SJC-11574, Commonwealth versus Ariel Hernandez.
And good morning, Mr. Kern.
Good morning. May it please the Court, Dana Curhan for Ariel Hernandez. I'd like to start off very briefly with the suppression issue. I realize that this is under the automobile exception to the warrant requirement, this is a difficult argument to make. This is an argument that my client feels very strongly about and would like me to present it. And without dwelling at length on the issue, there was an earlier armed robbery unconnected to this, to the home invasion. However, there was a dispatch where a description of the car was given. However, there was a dispatch that was that followed the home invasion, in which it was indicated that this car may have been involved in the home invasion. And I suggest that that is largely the basis for the stop in this case. That was based completely on a hunch by the officer.
But the car was exactly the car that the two victims of the robbery had identified.
It was. And
with the license plate number, no
Yeah.
less.
yes, and what I suggest is that the description of the persons involved was sufficiently vague, where there was something slightly less than probable cause.
But for the stop, I mean, you don't think there was reasonable suspicion for the stop?
Well, I think the stop was okay. I think once they determined, they immediately pulled the two occupants out of the car, handcuffed them, put them on the ground, and went in and searched the passenger compartment of the car. I'd say at that point, probably they did not have grounds to go in the trunk, and that would be my argument on this.
Okay, but what about the inevitable discovery?
I'm sorry?
What about once, accepting what you say, once they, do you have a question about bringing the one or both of, I can't remember, one or both of the victims of the armed robbery for a show-up?
They did bring one of the victims over, and she identified the passenger, not the defendant.
Right, but once she identified the passenger as having been involved in the robbery, what do you say about probable cause to search the car? Because there was a gun used in the robbery.
I think at that point they had already gone in and searched the car.
But that's why I'm asking about the inevitable discovery.
I think that what they did is they accelerated the search of the trunk in circumstances where they didn't have grounds later on. And I'm not sure if they would have grounds because it was actually the passenger who was arrested and not the driver. But again, I mean, that's the point I want to make, and I think it's probably time to move on.
Okay.
There are actually two severance issues involved. One involved whether the case should have been severed from the cases against the co-defendants, and the other was whether the case of the earlier armed robbery and the home invasion and murder should have been severed from each other. As to the co-defendants, obviously the elephant in the room for all three defendants was that there were a couple of witnesses who made deals with the Commonwealth and who implicated the defendant and the McDougals. And obviously everybody's going to address that, and all three defendants did. They talked about how they lacked credibility, et cetera. And that actually worked for the McDougall brothers because both were acquitted. But a secondary and a very important theme was that, for the McDougals at least, was that the people in the house identified the perpetrators as being Hispanic, I believe, in language and in appearance, and they were African American. So they said, essentially said, it wasn't us. Now you have three people on trial, and what they're effectively saying, it wasn't us, it was this guy over here.
Well, but did
they explicitly say it was this guy over here, or did they say it wasn't us because we're African American? It was, and all the witnesses are saying that the perpetrators were Hispanic.
Well, I don't think they said, I don't think they pointed directly at Hernandez and said it was him, But I think the implication in what they were saying and what their theme of their defense was that it was him. He's the only one it could
None
be.
of them, neither of them none of the three defendants testified, is that right?
No.
Of course, if they couldn't really say it was Hernandez, because if they said that, that would indicate that they had intimate knowledge about the details of the robbery. So all they really needed to say was, it wasn't African Americans, and we're African American.
Right, but but you only have one Hispanic on trial, and that was, I think that really pointed the finger at them. And there's actually a second point. One of the things Jamal did is he introduced a statement that somebody made saying that it was Jamal who actually did the shooting. Now, it couldn't have been Jamal who did the shooting because Jamal actually had a different gun. It wasn't matched to it wasn't the murder weapon. But what happened was the defendant told people in jail, hey, it was Jamal who actually did the shooting. And the judge tried to allow that statement to come in and struck the references to the defendant, but a couple of those references came in. So what the jury heard...
You mean they slipped in? I mean, it wasn't intentional, but they just slipped in.
They slipped in, and the judge struck them, but what the jury effectively heard was, okay, Ariel Hernandez was saying Jamal was the one who did the shooting, obviously falsely implicating him in the crime, so... but it also would have suggested very strongly that Ariel had to have been involved. So
I'm sorry, I'm a little confused. Jamal is one of the McDougal brothers?
he's one of the McDougal brothers.
How did you get past Bruton to have that statement come in?
Well, there were discussions beforehand. When that came in, when the first statement came in, there was a discussion with Bruton, and the judge says, says to Jamal's counsel, why are you introducing this? Don't we have a Bruton issue
Jamal's
here?
counsel introduced
Jamal's
it.
counsel introduced it.
I'm sorry, I missed that. Okay.
So what happened was this statement by Hernandez came in, and the jury heard that.
Okay, but the judge struck it, and did he say anything other than you just struck it, or what did he do?
He struck it, and then it came in again, and he struck it again. I mean, there's some reference to the defendant having said this, and he told the jury to disregard that, but, of course, that's the purple elephant.
How did it come in the second time?
Yeah.
It was, there was some, the same course of discussion. It was...
Who was the witness that put it in?
Or the lawyer?
Or the lawyer?
It was, I'm trying to think of who it was it came in through. I don't remember who it came in through. It did come in, and I do have the pages referenced, but there's just sort of the whole course of how that came in is really problematic to the defendant here.
With respect to the defense of the two McDougal brothers, I just can't remember this. Did the three cooperating witnesses, did they identify the McDougal brothers as well as Hernandez?
Yes, they did.
Okay, so it wasn't. All right. So how did the McDougal brothers say it wasn't just that they're liars? How did they say it wasn't that we weren't involved?
Well, they said essentially their defense was that addressing this was that everybody identified African Americans.
Hispanics. No?
I'm sorry, Hispanics. We're African Americans, so it couldn't have been us.
Oh, so they were saying that the four people who identify them were just wrong because they got the ethnicity, race wrong.
Right, and what they're also saying is that the cooperating witnesses weren't credible because essentially they said, yeah, the McDougal brothers came over and said to Hernandez, hey, let's go do this home invasion, and going to be real easy, and then one of the cooperating witnesses drove them over there, and they went in, and then they came out. So there was a very strong element of, I mean, I think the jury did not believe what a lot of these cooperating witnesses said. It was a fairly close case in that regard, and certainly it was problematic.
In the, with regard to these, to the McDougal brothers, was there any testimony that they solicited with regard to what language was used at the scene? I mean, you said they were Hispanic in language and appearance. Did the alleged victim, or did the victim say that people spoke in Spanish?
There were people in the house. I don't think they said they spoke Spanish, but I think there was some in language and in. I don't think I don't think this is clear. There's some discussion about they were Hispanic looking and possibly the way they were speaking.
The victim's Delgado, right? That's the, I mean, they're also
The two
Hispanic.
Delgado brothers.
Right?
Yes.
So it could have been that everybody was speaking Spanish. I mean, I don't know.
It could have been.
That wasn't in evidence, though.
Yeah, I'm not sure if anybody was speaking Spanish or was just speaking with an accent. I'm not sure. That's not clear. There were witnesses in the house, but a lot of them were upstairs and running up and down, and there were shots fired, and everybody was getting excited. The second.
But on that one, you have to say that they're mutually antagonistic defenses. How are they mutually antagonistic?
I think they're mutually antagonistic. Certainly, the statement that came in, that's mutually antagonistic. That's exculpatory toward Jamal and inculpatory toward the defendant.
Well,
Defendant object to that statement, by the way?
I'm sorry?
Did the defendant object to that statement at the time?
Yes, and there was a renewed motion to sever at that time, which the judge denied.
well, it may be inculpatory. I mean, at least on the surface, it's inculpatory of Jamal and exculpatory of Hernandez, right? If I'm getting this correct.
It is
On the
actually.
surface, I understand, right? Because it's a statement that Jamal was the one with the gun, right?
Well, it was a statement that Jamal did the shooting,
Yeah.
but it was introduced by Jamal's counsel to show that Hernandez was falsely accusing him, because what we knew at the time of trial is that the gun that Jamal supposedly had was not the murder weapon, so he couldn't have been doing the shooting, and what was happening is Hernandez was falsely accusing him in order to deflect suspicion away from himself. But that also suggested very strongly that Hernandez had to have been involved. Now, there's actually a second severance issue there, and the earlier armed robbery that night was actually tried together with the murder and home invasion, and that's a real problem. If we have, and I think it prejudiced the defendant as to both sets of charges. If there was a specific pattern, like let's go rob drug dealers, let's go do home invasions of drug dealers, and you had a home invasion of drug dealers and then you had another one, I'd say that may be a sufficiently close pattern. But this was a street robbery that took place 6 hours before the home invasion.
But it's the same gun.
It's the same gun, but we don't really need to,
And he's in that car. The gun's in the car. The gun is used to kill the Delgado brothers. I mean, wouldn't the Commonwealth be entitled to put that in?
Well, you can. I'm sure you can put it in. I'm sure you can put the gun in. You know,
And the robbery,
well, the robbery I have.
you've got to be able to find the gun and the defendant with it.
Well, I think it could have been handled by. We stopped a motor vehicle, we searched the trunk, we found a gun. The gun turned out to be the murder weapon. That's how it could have been handled. There's no need to introduce the earlier armed robbery. The Honda was not involved in the home invasion.
Right, I know.
They left it there and they went and.
Got a Camry.
It was a separate car. It was a separate set of people involved in the second robbery.
But robbery was the motive for the home invasion, just as the street event was, right? It's a common denominator there.
It's the common denominator, but it's a very thin common denominator. What it suggests is that the defendant has a propensity to do armed robberies, because with a group of people at 8:30 at night, he commits a street robbery. With a different group of people A few hours later, he commits a home invasion. A different car, different set of people, different victims, different modus operandi. And my suggestion is that it is, for example, to introduce if you're trying the earlier robbery, would you be able to introduce separately that later that night he went out and committed a murder? Probably not. Home invasion, I think it's...
Did the Commonwealth argue that one of the motives for the home invasion was his frustration at the inability to milk the ATM cards?
I don't think so. Your question is the first time I've heard that theory.
Well, it's in the brief that he was upset because he got so little money from the robbery.
Well,
Of the
I
two
mean,
women.
I'm not sure. That's an awfully thin.
I think the question is, was that something that the trial prosecutor argued, or?
I don't recall that being argued at trial, and I think it's a real stretch.
Do you recall if there was any testimony that he had experienced frustration at the low yield of the robbery?
I'm not sure. I mean, I think there may have been some frustration about how, they got $80, which I guess everybody was happy with, but he then sent out one of the co-defendants to use the ATM. He got the PIN, and he wasn't able to use it. I don't think he then said, "Oh, we better go do another robbery." What happened was they're sitting around hanging out with their friends, and people came in and out and bought marijuana from their friends, and then the McDougal brothers came over, and they saw Hernandez, and they said, "Hey, we got something you may want to get involved with." So it was the McDougal brothers who actually suggested this the home invasion, and what turned out to be the murder.
He got the PIN? How did he get the PIN? Was it in the wallet?
Apparently was in the wallet.
That's a bad idea.
Not a good idea at all. So,
How did he know? I'm just a matter of curiosity. I mean, this is sort of odd that somebody would stick their PIN number in their wallet, I think. How did he know it's a PIN number? Did it say, like, PIN number?
I don't know. It may have said PIN number or something.
Maybe he couldn't access it because it wasn't the PIN number.
That's quite possible, or she may have called up and canceled her cards by the time they used it. Or she may not have had anything in the account. But in any event, I think again, we have two severance issues, and I think they're both pretty serious and pretty prejudicial. And to illustrate the prejudice, in spite of all of the cooperating witness testimony, and there was quite a bit of it, the jurors acquitted 2 out of 3 of the defendants here. And I think tying, with all the severance issues, I think this may very well have tipped the balance in favor of conviction. Unless there are any further questions, I'll rest on the brief.
Okay, thank you.
Thank you.
May it please the court, my name is Casey Sylvia. I'm an assistant district attorney from Middlesex, appearing on behalf of the Commonwealth. First of all, I'd like to start with regards to the motions to sever. I'd suggest that the judge acted well within his discretion in denying both the motion to sever the trial of the co-defendants from this defendant and from denying the motion to sever the charges related to the armed robbery the defendant committed earlier the same evening of the murder. I do want to respond to Judge Botsford's question specifically about whether or not, with regard to the joinder of charges, whether or not the Commonwealth argued that in its closing. And I checked while that question was being asked, and in fact, it was argued in closing, and I also argued it in my brief.
The motive.
Exactly. That what it says in the closing is Ariel Hernandez wasn't happy about that because $80 from Ashley Cardozo and Sofia Danio was not enough. He wanted more. He wanted that opportunity. That opportunity presented itself to Ariel Hernandez when Jamal McDougal and Karan McDougal arrived at 80 Bridge Street. And I'd suggest that that is the motive all along, and that's precisely why that earlier armed robbery is relevant to the later home invasion, and that's precisely why these cases were tried together, because the evidence of that earlier armed robbery was not offered to show propensity. It wasn't offered to show the defendant was a bad guy, whether he was or not. It was offered to show a continuing course of conduct over the night of October 22nd, 2009, and into the early morning hours of October 23rd, 2009. It tended to show the defendant's motive, his state of mind, his knowledge, and it was a continuing course of conduct. I'd suggest even if those charges had not been charged, even if he had not been indicted that way, the evidence of the earlier armed robberies would have been admissible anyway at trial. Again, not to show bad character, not to show propensity, but to show that this was an ongoing pattern of conduct on that evening, and in particular to show the defendant's motive to then commit the home invasion when presented with the opportunity to do so. I'd also just point out that the Commonwealth went forward on all 3 theories of first-degree murder at trial, although the defendant was only convicted of felony murder. And so I'd suggest that the earlier armed robbery, or the somewhat failed earlier armed robbery, was particularly relevant with regards to premeditation, because it shows the defendant's state of mind and his planning process leading up to the home invasion of the Delgado brothers. And again, we did not prevail on that theory, but we did go forward on it.
Okay, and in any event, maybe your argument also is it couldn't have been prejudicial since he wasn't found guilty under it.
Exactly.
Let me ask you, could you turn to the question of this slip about the Hernandez and Delgado and not Delgado,
Jamal.
and the gun?
I'll be 100% honest with you about this. I went through that transcript yesterday. I went through it when I was writing the brief, obviously. I honestly don't know what my brother is referring to, and I'm not saying that to question. I don't know what witness he's referring to, and I don't know precisely what he is referring to. I think there was some discussion. I know there was some discussion about whether a statement by Jamal should come in, and that came in, I believe, through Joshua Silva.
And was something redacted from it, or intended to be redacted from it?
Really, my understanding is that statement had to do with what Jamal had done after the murder, whether he'd gone down to New York or to Boston, then ran out of money and came back and got arrested. And so I honestly don't know, based on my review of the record, and again, I went through it again yesterday, I don't know of anything that came before the jury that I just don't know what it refers to, truthfully. Although, I would suggest to the extent that there was some type of slip in front of the jury that was stricken from the record, if anybody had a Bruden issue, it would be Jamal. If that statement was made by Ariel Hernandez, it would be Jamal that had a Bruden issue, and he was found not guilty. So I don't really think that would be the defendant's challenge to assert at this point. I'd also just say, with regards to the joinder of the co-defendants for trial and the issue of race, my understanding is there was one witness, it was Brian Staples, that made a few statements about the race of the perpetrators of the home invasion.
He was one of the residents of
7 Marshall Terrace, that's correct, Your Honor. And what he originally said on direct was, this was the question, could you tell what race that person was? He had dark skin, Spanish. It wasn't white-colored skin. And then on cross-examination, again, it sounds very much like, this is what he says. And you gave the police officers that night, you initially said that the 2 people that were there were black males, is that right? Black, Spanish, yes. And then again, he repeats, you didn't say black speaking, you said, strike that. What you told the police that night 2.5 years ago was that these individuals, both intruders, sounded as if they were Spanish, correct? Yeah, and that's your best estimate, correct? Yeah. And then he says again, yeah, I told them he was Spanish, black. And so this is what I'm going to suggest, Your Honor. My understanding is that the defendant is Dominican. I don't think it's mutually exclusive to be both black and Spanish speaking, especially if you have a Dominican defendant who's quite dark-skinned. I think that the testimony was somewhat equivocal on were they Spanish, were they black, did they sound like they spoke Spanish. It's not impossible to appear to be black and to also sound like you speak Spanish because you're Dominican or because you're a black Hispanic. Like, that's just not, those are not mutually exclusive things. And so my understanding is that is the basis of that argument, is that witness's testimony. I think even if what he was really saying was unequivocally these 2 were Spanish or Hispanic or Latino and that's it, that's all they were, I really don't think that it matters. As Judge Billings pointed out when he repeatedly denied these motions to sever on those grounds, it's not as if there is only one Hispanic person in the city of Lowell. I think what he said somewhat flippantly maybe was there are plenty of Hispanics to go around. So it doesn't necessarily point the finger at the defendant. It doesn't suggest that he has to be the only one that's guilty simply because he happens to be Latino. Obviously, there are many other people in the city of Lowell who would also fit that description. And the fact that it made it somewhat more likely, strike that, it reduced his chances of acquittal. I don't think that that's the standard for do we sever co-defendants at trial. And I think, frankly, that's what this argument amounts to. It amounts to, I would have been more likely to be acquitted had I been tried separately. First of all, I don't think that's true. But secondly, that's just not what the standard is when it comes to a motion to sever.
Was there evidence that he was Dominican?
Excuse me?
Was there evidence that he was Dominican?
So, Your Honor, frankly, I've seen the defendant, so I know that he
I
does
gather,
appear to be
but
Mexican.
I'm just wondering whether or not in the record there's any evidence that he was
What I would
Dominican.
suggest in the record was the defendant, this is what was in the record. The defendant was driving his sister's car. His sister's car had a Dominican flag hanging from the window. I think it's a pretty fair inference that he and his family members are Dominican.
Was there an interpreter used at the trial?
No, there was not, Your Honor. And again, I'm not really sure what the testimony meant with regards to they sounded Spanish. I honestly don't, and my brother probably has a better idea about whether his client speaks with a Spanish accent or not. I truly do not know. The way I originally read that testimony was that they appeared to be Latino or that they somehow had an accent that sounded Latino, but again, I don't think that excludes them from also being black.
Did the two robbery victims describe any accents that the robbers may have had? In particular, the taller one that had the hoodie? Or was the only description that they gave was that he was taller than the other guy and he wore a hoodie?
Yeah, Your Honor, not that I recall about the Spanish accent. I do think that there was testimony that he was Spanish. I know that one of the victims was herself Dominican because she said that on the stand. The other victim was someone who also appeared based on her last name to be somebody of Latin descent. I honestly do not know about whether or not they sounded Spanish or not. I don't recall that there being testimony about that. What I do recall is her saying, the victim that was of Dominican descent, I do recall her saying, I recognize the flag on the car because it was the Dominican flag and I'm Dominican.
Okay, but I know this is not what you're arguing, but on the question of the suppression motion, exactly what does the record indicate that the two robbery victims had reported to the police that was descriptive of the taller man that wore the hoodie?
At the motion to suppress, with regard to the motion to suppress, the only description that came in at the motion to suppress was that they were two Hispanic males.
That there were two Hispanic males?
Yeah, that
And
was
is that what the police knew at the time of the radio dispatch, that the two robbers were Hispanic?
Yes, that's correct, Your Honor.
Okay.
At the time of, so with regards to motion to suppress, at the time that the stop took place, that is what the police were aware of. And the judge inferred that that information came directly from the victims. I'd suggest that that's not only is that a reasonable inference, but that is in fact what happened. But that it was a very bare bones description from those two of the perpetrators at that point, at the motion stage. You know, there was more description given at trial, but at the motion stage, it was that there were two Hispanic males. The very in-depth description was given of the vehicle. You know, they had the make, that it was a Honda, the model, that it was a Civic, the color, that it was green, the same license plate number, I think it was Mass 121GN8, the same flag in the rearview mirror, the Dominican flag. So the really strong description, I think, came of the vehicle. So I'd suggest that the probable cause was to search the vehicle. Certainly the fact that there were two Hispanic-appearing occupants in the vehicle
You really think
helps.
at the time of the search that there was probable cause?
Probable cause to search the vehicle?
Yeah, as opposed to a reasonable suspicion for the stop?
Your Honor, absolutely. I think there are two separate questions, maybe whether there was probable cause to arrest the two individuals in the car and whether there was probable cause to search the car. I wouldn't argue that there's probable cause to arrest the two individuals at that point. I would suggest that there was probable cause to search the vehicle, though. Whether or not those two individuals were the two that committed the robbery, it's helpful if they were, frankly, and I think that, you know, they had a reasonable suspicion they were. But I think there was probable cause to believe one way or another that vehicle was involved in the armed robbery, and that, frankly, the vehicle itself was evidence of the armed robbery because it was the same vehicle, but that it was more than likely.
To look for the purses and as well as the gun.
As well as the gun. And actually, I suppose also, you know, fingerprints or DNA to show who had been driving the car. You know, we do that, obviously, in some cases where we take DNA and fingerprints, you know, off the wheel to show who was operating.
But wasn't there some kind of, maybe my memory is not good about this, but wasn't there some confusion about what car was involved in connection with the home invasion? And that the police were looking for the first car, but that actually wasn't the one that was involved.
That's correct, Your Honor. And Judge Billings did not take into, so this would happen. There was originally a BOLO, be on the lookout, for the vehicle involved in the armed robbery. And that was the green Honda Civic. The full description's given. The 2 Hispanic males as occupants is given.
And that had been going on since the armed robbery.
Exactly. And then after the home invasion, Your Honor, a description of the car once again goes out. And it's not clear what the
Of the
basis.
same car.
Exactly, Your Honor. And it's not clear what the basis of knowledge was for that. But the officer actually says in the stand, he thinks it's information based on that earlier armed robbery. They're assuming the two are connected. And so as a result, the only
But they
information...
did have other information, right, that it wasn't that car, that it was...
Later on, they had that information. I really don't think it was at the same time, because they got surveillance video later on showing that it was Joshua Silva's car and not the green Honda Civic, which I think that was a Toyota, a later model Toyota. Judge Billings, though, did not take into account that information in determining whether there was probable cause. He did appear to take into account the fact that the 2 occupants of the green Honda Civic, who'd also were suspected to have perpetrated the armed robbery, met what he called the very general description of the 2 home invaders. And the police also knew that a handgun had been used in that home invasion, and it was in close proximity to the earlier armed robbery. But that's the extent of what he considered. He did not consider the dispatch that included the description of that car a second time. Frankly, possibly because that is not actually correct. That is not the car that was used in that in the home invasion.
How close was the robbery of the 2 women to where the home invasion was?
It was within about 50 yards.
Really close.
But it was
Very
6
close.
or 7 hours later, right?
Yes, that's correct, Your Honor. It was, I believe it was 6 hours later. I counted it up yesterday. But I believe it was approximately 6 hours later. It was within 50 yards of the earlier.
What was 6 hours later? The stop of the Honda or the?
The stop of the Honda, Your Honor.
6
but
hours after
it
the
was about
robbery.
5 hours between the 2 crimes.
Exactly, Your Honor. That's correct. I'd also suggest that the defendant's behavior in the car, when he behaved in such a completely disproportionate way to being pulled over for blowing a stop sign.
Oh, really?
I'd suggest that I don't think it provided probable cause, but I think it elevated the suspicion at that point. I don't think it provided probable cause to arrest, but I think it helped with regards to probable cause to search the vehicle.
Some people can't control their emotions. I don't, that's just...
That may be true, Your Honor, but that's I would suggest that. I'd also just point out again that that the murder weapon in the trunk would have been inevitably discovered regardless of this, whether there was probable cause at that point. If Your Honors determined there was some deficiency or that it didn't quite amount to probable cause to search the vehicle at that point, although I would suggest there absolutely was sufficient probable cause, that the gun inevitably would have been discovered because of the fact that the police were just waiting on getting one of the victims to the scene, and that she inevitably would have identified Mr. Hill as one of the 2 armed robbers, which she did. And then at that point, under the case law, at the point at which he was arrested, they would have had the right to search the entire car, including the trunk, for evidence of the crime for which he was arrested.
Does it matter that Mr. Hill was not the driver, in your view?
No, Your Honor, I don't think that makes a difference, at least not under my understanding of the case law. I don't think, for instance, that the Gantt case forecloses on that possibility. But no, I don't think that makes a difference. I'd also just, I would just ask the court this, which is what else the officers really could have done or should have done at that point. I'd suggest that probable cause really turns on the facts and circumstances that are known to reasonable people as they appear at the time, not the facts and circumstances maybe as we would parse them out later on as lawyers, and that at that point when they're standing on the street in Lowell, at 2 o'clock in the morning, and they've had this earlier armed robbery, and then they've had this home invasion where 2 people are dead, as a result of the use of a handgun again, that at that point to them, the facts and circumstances really did appear to be quite serious, and to suggest that this vehicle was absolutely involved and that it would yield, and a search of it would yield evidence relevant to at the very least that first armed robbery. And I'm just not sure what else those officers could have done at that point. Frankly, impounding the vehicle, I think would have been, you still would have required the probable cause. Impounding the vehicle and getting a search warrant, would that have been an option? It would have been, but I think that's why the automobile exception exists, for precisely that reason, so they can search the car right then when they do have probable cause. So I just suggest that that was really the only good alternative that was open to the officers at that point, as they stood on the street in Lowell, several years ago at 2 in the morning with these two people they suspected of an armed robbery and then possibly a later home invasion. So if there are no further questions from the panel, I would just rest on my brief.
All right,
Thank you.